Good evening, Captain Retired Matt Edwards here with the next weekly installment, if I can get back on track, for the Observation Post weekly Facebook Live broadcast. Now, I'm kind of up and hot and bothered about a couple of things that happened recently, so I'll probably get into them after, but I'll first go through 3 items from that number list I'm always talking about that's located in the files in my Observation Post group. Number 448. Retroactive flat rate must be off limits, as the Canada Pension Plan contributor is meant to get that. Now, that's a offshoot of my idea that a flat rate has to be off limits, because the government, when they set up the flat rate, which has nothing to do with the economic portion of the Canada Pension Plan, it's meant to go to the pensioner. Now, it's a fairly high chunk, especially, if you're early in your career when you become disabled. In my case, it's about half. So that's, that's obvious when you think about it. Number 449. If Canada Pension Plan tried to take away my Canada Pension Plan disability now, if they tried to take it away because I never should have gotten it, I would fight that decision. Number 1, they unlawfully paid it since 2014. Too bad for them. And number 2, I told them about it in 2016. Now, there's another equitable argument. I forget what it's called exactly. But basically, you get used to something. So they should have followed the law. They didn't follow the law. I got awarded Canada Pension Plan disability without lawful right, and I told them about it. They didn't take it away then, and now I would say it's too bad for them. Number 450. Veterans Affairs Canada uses insurance principles. Well, they're not really principles, but they're unsavory tactics. Delay and deny, confuse and refuse. Don't inform veterans about benefits. Pretty sure everybody knows that. They think if you don't know about it, you can't apply for it. You can't get it. So that saves them money. That's pretty easy to understand. Now, I winged through those really quick. Let me tell you about a couple of things that have been bothering me recently. Well, maybe I'll start with one and see how long that takes. I got a call. I didn't answer the voicemail. I didn't get the call right away, and I let it go to voicemail, and it was for Sun Life. Now, I figured it seems like I might have forgot to send in that annual form. Like the Service Income Support Insurance Plan has an annual medical. Sun Life doesn't do a medical. They send you out a one-page form. I'm pretty sure I forgot it again. Now, when I called them up, sure enough, that's what it was. So they said they're getting rid of that paperwork, that one-page form, and they're going paperless. That sounds good in theory, but then, well, partly due to my own fault, I ended up talking for an hour and 45 minutes with the guy. That's because I was lecturing him about all the things they can and can't do. Now, even though the gist of the form is basically, are you still disabled? Sign and date it and send it back. They wanted to update the file, and they kept asking me all kinds of questions, which really bugs me. Because we should have the right to privacy, okay? If the government wants information from us. Now, before I go further about that, I'll say why I'm blaming the government. There are 4 federal government long-term disability plans. I was with Canada Revenue Agency, so I was covered in my civilian job by Sun Life policy 12,500G. Now, that plan came into existence in 1971, and it was paid right from the start, 50% by the government and 50% by the employee. Now, to contrast that, the grandfather long-term disability program was a Service Income Support Insurance Plan, the first one of its kind. It started 2 years earlier in 1969, and it had 100% payments by the Canadian Forces member and nothing by the government. But when the Sun Life policy came into effect in 1971, they decided to make the CPPD policy the same thing, and they started to pay half of the premiums. But there was a big difference. the Sun Life policy was mandatory, I'm pretty sure, for everybody in the government that's unionized as a term of their contract, maybe. But the military left it freedom to contract. You didn't have to buy CPPD. Now that changed in 1982, but the gist of my broadcast tonight is going to be Sun Life and not the Service Income Support Insurance Plan. So basically, there's Sun Life, like I said, for the unionized public service. There's the Manulife policy that used to be Maritime Life for the military. The RCMP has the Great West Life policy, and the Public Service Management Insurance Plan is now with Industrial Alliance. So there appears to be 4 different insurance companies that are underwriting these policies. But that's not true. That's a lie. The Manulife file with the military, if it was Manulife underwriting the policy, then Dennis Manouge would have sued Manulife and not the federal government. That's common sense. It's also law. You can only sue in a contract the parties to the contract. And they decided to hear the case as a contract dispute, and Manulife was nowhere to be found. Now, the other part is that there was a concurrent case waiting for the Manouge case to be decided for the RCMP. And the Great West Life policy didn't have Great West Life get sued by the Butte estate for the RCMP disabled members. No, it was Her Majesty the Queen at the time. So, that's 2 of the federal government plans that had the federal government get sued and not the insurance companies. Now, there was another case. At the time, it was National Insurance, I think it was called. And that was for the Public Service Management Insurance Plan, and that's the one I mentioned that's now with Industrial Alliance. So when that went to court, it was about taxes. And I spoke to the lawyers who represented the government. It was McInnes Cooper. Now, I meant to call Bruce Bryan's lawyers, but I accidentally called the opposition. So I mentioned to the lady lawyer I spoke to, I said, listen, I got you on the phone, can I ask you a question? You might not want to answer it. How come the government of Canada didn't get sued instead of national insurance? And she said, well, we made that argument to the judge and he didn't accept it. So that put my mind to rest, sort of, because at least they tried and it wasn't their fault that it got misreported. But maybe they should have tried harder, because the 2 other cases that McInnes Cooper, they are the common denominator here. So McInnes Cooper did the Manouge Great West CPPD case, they did the Butte Estate Great West Life case, and they did the Bruce Bryan Industrial Alliance / Public Service Management Insurance Plan. The same firm was present in all of these cases. Now, you have to wonder, why did the civilian side case get away with it? Because that's the way I term it. On the military and the RCMP, these people are not employees. Okay, Canadian Forces are members, and so are the Royal Canadian Mounted Police. They're members of the force. Now, there are other differences between the policies. On the civilian side, the Public Service Management Insurance Plan and the Sun Life policy are both 70% of insured of your salary. The military and the RCMP are 75%. Well, there is also a difference in the cost of living allowance. With the CPPD file for the military, it's limited to 2%. For the RCMP, it's 3%. And for the civilians under the other 2 plans, it's 3% as well. That's inequitable. You can't say that a disabled Canadian Forces member, a veteran, is less worthy than a disabled RCMP member or a disabled public servant. It's just not on. Now, anyway, getting rid of this and opening up my Sun Life notes. I was going to see a thing here that, like, I'm just winging it like usual. Now, one of the things that I have a copy of the contract, or part of the contract, whatever you want to call it. See, I don't think there's really a contract. In the Manouche case, for example, the judge said, his name is Justice Robin Burns, he said that there wasn't a contract between the soldier and Manulife. There was a de facto contract between the Chief of Defense Staff and the Canadian Forces member. Now, I keep thinking that these judges should be more competent, because when I looked up the definition of a de facto contract, it said that it wasn't what I believe he meant, that it was an implied or unwritten contract. That's what I would term it as. But a de facto contract is one that has some material problem with the contract. It's not valid. So I don't think he should have used that term. Maybe implied contract would be a better way to put it. There's nothing on paper. But in all of these cases, it says the name of the company as the underwriter or insurer, and it lists off, say, the Sun Life policy. It says it's Treasury Board Secretariat. And let me get it up here so I can read it off. Here's what it says. The policy holder, I'm looking at my Facebook page. The policy holder is described as Her Majesty the Queen in right of Canada, represented by the President of Treasury Board. Now, let me stop them pricks right there. Under the law, the Financial Administration Act, Section 7.1, brackets 2. The Financial Administration Act does not apply after they set up a benefits program. So Section 7.1, brackets 1, gives the government the authority to create benefit programs, insurances, pensions, and stuff like that. But once they set it up, they are supposed to be hands-off. So this alleged contract between Sun Life and the President of Treasury Board is in violation of federal law, right there. Do they care? Doesn't seem like. When I spoke to the Sun Life person the other day, I said, listen, let me pick your brains a bit. Tell me, have you ever heard of the word sponsor? Like the government sponsors the Sun Life policy? No, he hadn't. Now, in retrospect, it might be that I've seen that mostly with the RCMP and the Canadian Forces insurance, that they talk about the plan sponsor. Well, the plan sponsor and the plan policyholder is supposed to mean the insured, the one who owns the policy. Now, insurance is property, and that's why they say policyholder, because you own it. Well, Treasury Board doesn't own the Sun Life policy. It should be the same as in the Manouche case. The people who pay into the insurance, like all insurance, they are the ones who own the policy. Now, I could put a caveat in there. The caveat is that many times insurances or contracts, you can have a beneficiary name. They don't have to be party to the contract. So you can give a benefit to a third party that didn't negotiate the contract to a beneficiary. But there's a contract law rule that says you cannot put an obligation on someone who didn't have a hand in negotiating a contract. So presumably, Treasury Board negotiated with Sun Life, and they hammered out a deal, even though they didn't realize that it was illegal, even though that's not going to work because ignorance of the law is no excuse. But the thing is, they have this policy that is basically, this is one of the main problems that I have with these insurance plans. Not just me, it should be anybody when they know about it. I explained to the Sun Life representative the other day. I said, listen, here's the way it works when you have three parties to a problem. Say you have an insured person, you have an employer, and you have an insurance company that you actually have a real insurance policy. Everybody is going to look after their own interest in a dispute. So you have the employer will look after their own interest, the insurance company will look after their own interest, and the disabled person employee will look after their own interest. But if you have an employer-sponsored an administrative services only insurance policy, and that employer then hires a company to administer its policy, then you have a two-party system where it's the employer who acts as the principal in the agent principal status, and the insurance company that's hired to act on behalf of the employer. So those two parties form one party. And then you have the other person getting ganged up on by what appears to be three parties, but there are only two parties. Now that's a violation of both regular contract law, which is every contract has the implied duty of good faith, but insurance contracts have a higher duty implied into it called utmost good faith. Fide muratis or something in Latin. I haven't got it in front of me, so I really shouldn't have even tried to say it. Which is an interesting point, and I'll make it here because it's fresh out in my mind. Normally, an employee and their employer negotiates, and there's no holds barred. They try to get the best deal they can because their interests are in opposition to each other. But you do have the implied duty of good faith. Remember, no shenanigans, no dirty dealings, no lies, no cheating, stuff like that. But if an employer sells an insurance policy to its employees, it has assumed voluntarily by selling the insurance policy to the employee a higher duty, the utmost good faith duty. Now, I'm sure they don't think of it that way, because they probably think in legal terms that we just, we got this insurance policy and it's just, we got to treat everybody legally and by the book. No. You have to treat people more than just legally. The utmost good faith means you can't. I look at it almost like a fiduciary duty. A fiduciary duty is when someone who has a fiduciary duty has to look after the other person's interest before themselves. Well, let's look at clawbacks, because that came up a bunch of times. Clawbacks save money for, on paper, it appears to be the insurance company. But in reality, it's the employer. Now, remember, the employee and the employer at loggerheads when it comes to their interests, they're not the same. So hiring an insurance company to fake out the employee, I think it could be criminal, but it's certainly civil fraud, because you've used deceit or deception to put someone's economic interest at risk. Okay? So, now, that point I made about the policyholder, that's also about the service income support insurance plan, because in the contract, or the alleged contract, that states that the chief of defense staff is the policyholder. Now, see, when I've been looking up all this stuff over the years, it wasn't all recently that I discovered all this stuff. Many of these things that I discovered, found out, were years ago. For example, a case that I found was about the employment insurance deductions that were supposed to be, according to Canada Revenue Agency, my old employer, long-term disability insurances should be taking them out according to CRA, and they took them to court, several employers, to assert that right. So the first one was the Université de Laval, Federal Court of Appeal, 2002, and they said that the government did it right. The government's position was right, and that the source of the payment was the employer, not the insurance company. So therefore, because the source of the payment was the employer, then employment insurance premiums had to be deducted. So they basically said that this was insurable employment, which was false. It's not. And in the National Bank of Canada, 1 year later, Federal Court of Appeal case, I'll read it off. In paragraph 11, now I got this truncated, chopped off of it, so I can't read off the top of it, but I'll start out with this sentence. That being said, with all due respect to the respondent, we do not see an inconsistency between the facts of this case and the statement in the guide, I think they're talking about the payroll guide, concerning the determination of the employer of eligibility for benefits. Not only is a financier manuvi not an insurer, it is also not a third party, and certainly not a third party insurer. Now, let me explain why, because the judge didn't say that, he made a statement. Goes back to what I was saying before about the principal and the agent. So they formed the same party, so therefore, they're not a third party. The dispute is a first and second party dispute. There's no third party insurance, there's first party insurance. So, in fact, it acts on behalf of and in the name of the employer who's bound by its decisions. As indicated in several places in the contract, it is the agent of the employer. And accordingly, the decision of financier manuvi as to the eligibility for benefits is, in fact, in law, the decision of the employer. Now, I could question the judge's credibility again because he's talking about the decision about eligibility for benefits, but the case was about employment insurance. It's not the same thing. So, again, this is chopped off, but paragraph 12. The Tax Court of Canada did not have the benefit of this court's decision in University of Laval when making its decision, which is kind of fucking stupid when you think about it. It was a year earlier. So, this court didn't matter because the other one was a past precedent. Stupid son of a bitch, this judge is. And it erred with respect to the definition of employment, insurable employment, as set out in the Acts and Regulations. I mean, that sounds like a crock of shit to me. Okay, look. I've said this so many times, I feel bad about saying it again. I feel guilty about having to hammer this home, repeat myself about this stuff all the time. If you're on long-term disability, like the person that was working for National Bank of Canada, you are unemployed. Because of disability, but you are unemployed. You don't have a source of income by providing service to your employer. Instead, you get long-term disability insurance proceeds because you bought a contract of insurance, and because you're unemployed because of disability, you get the insurance. Now, the purpose of the employment insurance system, which used to be called unemployment insurance, is to provide benefits to people who are temporarily unemployed in between jobs. It's not meant to cover a disabled person who can't work. It's just not the design of the program. So what this case has resulted in is a windfall for the employment insurance program because people who can't access the employment insurance are being required to pay into it. Now, why did the employer take this to court? Because if it was just money coming off of the former employee, the disabled person, they wouldn't care because they're just following the law, they just send the money. Well, the Employment Insurance Act states that you had to put 1.4 or 140% of whatever you take off the employee's check. Before you send it to the government, you got to put say the payment was $10. You got to put $14 from the employer's own money with the $10 from the employee's money, and you had to remit $24 to Revenue Canada, who then sends it to the employment insurance people. So that's an expense for them, and that's the reason why I think it's all being done wrong, even though they should be doing what the federal government long-term disability programs are doing. They shouldn't be taking it out, period. But basically, they set up a system for everybody else that has a long-term disability program. This is what you'll do, and we'll get more money. But for the federal government program, they decided that they were going to not do it because they didn't want to spend the money. That's just not okay. That's against the rule of law principle. That's anti-democratic. Now, getting back to the Sun Life policy. Okay, so I'm there talking to the guy, and he's asked me all these questions. And he said, do you have any other pensions besides your public service superannuation act pension? I said, yeah, I got a reserve force pension plan for the military. Okay, well, I'll have to send that up for review to see if we're going to claw it back. He didn't use the word claw back, of course. I said, you hang the fuck on. You guys knew about this and you haven't been taking it into account for many years. I always thought the deal was that Manulife was taking my reserve force pension plan into account, and they didn't even try to take my public service pension into account. You guys were taking the public service pension into account and weren't touching the reserve force pension plan, and I thought it was like a gentleman's agreement between these two fucking insurance companies, which are screwing me over. Unlike the Canada Pension Plan and Disability, which you both were taking into account, but the federal government pensions, you both left the other one alone. I'd have a big problem if all of a sudden you tried to claw it back now and get a windfall. I said there's a concept of waiver in the common law, and you have waived your right to do it. The Canadian Forces Superannuation Act, Section 83, and the Financial Administration Act, Section 67, prohibits it, so I don't care if it's in an alleged contract. You can't do it because of federal law. In addition, I think I mentioned this to you before about I never had a hand in any of the terms in this contract. I didn't negotiate it. I didn't sign it. So therefore, I'm not bound by its terms. Go to hell, in other words. Now, so, you're not going to cooperate with the rest of the questions? Well, we might have to cut your benefits off. No, I said, I'll answer the rest of the questions, but listen here, you should know what you can and can't take into account. And I said, by the way, seeing we're talking about my Canada pension plan, I just brought it up. Run it by your legal department, will you? See if the fact that I shouldn't have got it in the first place, I didn't have enough contributions to get it legally. The minimum qualification period is called under the Canada Pension Plan Act. You had to have 4 out of 6 years, and I had 4 out of 7, so I was told officially by Service Canada, 26th of July 2013, that I could not get it. Now, you guys pushed me into applying for the 4th time after that 3rd application got denied, and then I got approved. Now, I'm a veterans advocate, and I've come across a lot of people like myself who probably shouldn't have got it. They were unlawfully awarded or had people trying to push them into applying for something they couldn't get legally. That makes me real suspicious, especially when, you think about it, you guys aren't really the insurance company. I said, say the Canada Pension Plan Disability. If I had signed the irrevocable consent form, and I had sent it to Service Canada, and then they had sent my retroactive payment directly to Sun Life, would you have remitted the money back to the Canadian government because they are the underwriter of the policy, and therefore if anybody is going to get that payment, they have to get it, not Sun Life? Or do you give the government credit and then they have to make a less payment because you already have some of the money? I think you put it into your general funds and you keep it for yourself. I think you get a windfall out of this. Now, I might have also mentioned that I think this is, I'm not sure to be honest, the taxes, okay? There's a tax policy issue that I'm pretty sure I'm right in identifying, that if we didn't have clawbacks, we would have higher income, and therefore the Canadian taxpayers would have less of a burden because we will pay higher taxes. But on paper, Sun Life gets a benefit by clawing back the Canada Pension Plan and my public service pension, which means I have less income, which means I have less taxes because they clawed money back that they shouldn't have clawed back. So you can't say that this is a good public policy to have clawbacks on insurance because it's hurting the nation's tax system. Now, I'm waiting for, if I use that argument about the government insurance, that the government would say, well, we save money on the clawbacks, so we get more money there than the taxes we would have received if we didn't claw it back. If they'd be that stupid to say that argument, that point. We all know that that's what they're doing, but would they be dumb enough to say it? Because they are the ones who put Sun Life down as the insurance company when it's actually the government of Canada. They are the ones that are making it appear as if there's a third-party insurance company, when I'm sure they're aware, because of them cases I mentioned, that it's public knowledge that these companies don't underwrite the plans. They only get paid to do the paperwork. They're basically accounting firms. Now, they might do other stuff, like the service income support insurance plan, when the deal was in the 30th of March 1991, I believe, that the Chief of Defense Staff took over effective control of the service income support insurance plan, accepting the establishment and maintaining of the insurance reserves. So basically, they left it in the hands of the maritime life people for investing the pool of money that creates the insurance policy. So people pay the premiums, it goes into a pot, gets invested, whatever, and then claims get paid out of it. Well, the government appears not to want to have to invest it, so they basically gave the money to someone else to invest, which is kind of like having the ducks look after the hen house, I think, is the saying. You know, they do all the hard work. They look after the insurance policy, except you're going to give the money to some outside party. That's kind of crazy when you think about it. Well, so I was talking about taxes to the guy. I said, you see, I got this problem. Like, I used to work with Canada Revenues. And ever since I've been on Sun Life, which is 2008 or so, December 2008 or maybe March of 2009, I've been getting T4A tax information slips from Sun Life, which are false. The underwriter is His Majesty the King now, and it was Her Majesty the Queen. But Sun Life is sending false paperwork to CRA. Now, I don't want any part of whatever scheme you guys have where you're sending in fake paperwork to the tax people to try to fool people. It's like, it's not right, okay? If you're going to do it properly, you have to put the government of Canada on it. But you see, the problem is, if they acknowledge that it's the government of Canada, then they have to do things differently. They have to stop clawing back because there's a conflict of interest, being the former employer and the former employee. Then there's a conflict of interest there. You're clawing back money. Why should I have to subsidize my former employer? I got nothing to do with them anymore. Now, on that point, again, because I don't know if my brain will go back to it or whatever, there's another crucial difference between the Sun Life policy and the Service Income Support Insurance Plan. In order to get the military's long-term disability insurance, you had to be terminated from the Canadian Forces. You had to be no longer in the military. But for the Sun Life policy, that's not true. I was a Canada Revenue Agency employee for 3 more years after I became disabled. I was on the Sun Life insurance policy, but I could have went back to work if I had recovered. And that's the ideal solution. No one wants to remain on disability. They would rather keep working. But when it came time for them to fire me for becoming disabled and I didn't have any union representation, I was kicked to the curb and I had to apply for a disablement public service superannuation pension. And then that was clawed back when it was approved by Sun Life. So seeing we were talking about that, I said to him, listen, how much are you taking off for this or that to count the pension plan and the public service pension? He told me, and it was higher than the original award. Well, I said, you're violating the contract. In the contract, it states that the cost of living allowance for a clawback amount will not be touched. Now, you're telling me that you're taking this much off of my Sun Life policy and insurance, but it should be lower if you knew how to read. Now, what it says, and this is not the contract, but it's something that the public service puts out. The following are examples of income that would not be deducted from your disability insurance benefits. And they got a bullet point here: increases related to the cost of living under the Public Service Superannuation Act, the Canada Pension Plan, or the Quebec Pension Plan. So basically, to put it in layman's terms, my Canada Pension Plan disability was approved originally for $1,017.94. Sun Life should only, if they're allowed to do it at all, according to the contract, they can only take $1,017.94 into account because of the exclusion of the cost of living allowance. Now, they're all doing the cross count. The insurance industry across the board, they're all taking the cost of living into account, which is wrong. They might not all have it built into the contract like the federal government does, but basically it's against public policy to take into account. Say, for example, you got 10% because of high inflation, adjusted to the Canada Pension Plan disability, but your insurance is limited to 3%. Now that means that the people doing the clawback are getting a 7% windfall because your Canada Pension Plan disability went up by 10%. Your corresponding insurance went up by, say, 2 or 3%, 2% for the military's long-term disability, 3% for all the other federal government long-term disabilities. So the military plan would have an 8% windfall for the government, and the civilian insurances would have a 7% windfall for the government. They're making money on the backs of a disabled person, which is despicable. Despicable. Now, I'm going to mention this, even though I'm going to get a bit off track. I seem to be going on a nice smooth flow, but I'm looking down through my pictures here. Now, one of the things that I've been saying, and the Department of Justice in the Manouche case vehemently denied that there was a administrative services only policy in effect for both the RCMP and the Canadian Forces long-term disability programs. Problem with that is that it's a lie. Now, they based their argument on the fact that there were actuarial reserves put into the bank to pay claims out of. And they said that administrative services only policies don't do that. But that's false. Who is to say that you can't set up an administrative services only policy with actuarial reserves? The government did it for the Great West Life and the Manulife policies for the military and the RCMP members. And it wasn't Sun Life or Manulife and Great West Life who got sued. It was the government of Canada. Now, on the Sun Life side, I've done a lot of digging, a lot of review, a lot of research. In the 2006 National Joint Council, because they're the ones who are tasked with to be a step away from Treasury Board, sort of, reviewing ongoing disability insurance and advising disability insurance plan stakeholders on the following topics in connection with the Treasury Board Secretariat planned audit review of disability plan. Number 1, elimination period. Now, I don't think CISIP has that, but the Sun Life policy has a 13-week period where you had to have no income and nothing else, or you can't get the insurance. So basically, that's subsidizing the insurance plan. Coverage of seasonal employees, I'm not even going to talk about that. Coverage of term employees, well, generally full-time employees get all the benefits and term employees get screwed. That's the way it is. Provisions for pre-existing conditions, they should go fuck themselves on that, because I've seen a lot about that, about the Obamacare in the States. They try to get out of paying stuff to people because they had a pre-existing condition, and we're not going to cover that. Coverage while on leave without pay, well, I don't understand that one. Because if you're on leave without pay, you're already on the disability, so you don't need to have coverage for another disability. What the fuck are they talking about there? Here's the main one I put stars by when I was making this picture. An administrative services only arrangement. Now, let me explain the background about government insurance. The government, as a rule, doesn't buy insurance. It doesn't. It just doesn't. There's a policy against buying commercial insurance. So, if a RCMP cruiser or a military truck gets into an accident, there's no insurance that, pays for the damages. The people got to make a claim to the government to get paid because the government self-insures. Now, the public service health care plan, for example, that's a pretty big drug plan, and that is openly administrative service only, and that is, at least they're open with it. But the 4 federal government long-term disability plans, they try to say these aren't administrative service only, despite the fact that they've been taken to court. And it is what it is. It's a fact that these people, Sun Life does not sell insurance to the public servant. The RCMP do not buy insurance from Great West Life. Now, you want proof of that? Look at the 2006 Fall Auditor General's report into the pensions and long-term disability insurance for the RCMP. And they found a lot of problems. They said that these plans were corrupt. And, well, if they're corrupt, well, why wouldn't these plans be corrupt as well? There were people going on trips using the money from the funds, and people hiring their friends to administer the policies and stuff. I mean, it was just crazy what they were doing. Anyway, so anyway, I mean, I'm kind of getting tired of this. Maybe I'll do another video later, but a lot of this stuff, I think I can sum up. Like, I'm trying to think of a way to basically take them to court eventually, because I'm pretty sure that my reserve force pension plan is all of a sudden going to get reduced. They'll reduce my Sun Life by the reserve force pension plan. It's only about $150 a month. It's very low. And I had to fight like a dog to get it, okay? Took me 9 months of fighting with the pension administrators before they finally approved me, and they approved me based on the fact that I submitted my disability tax certificate as evidence. I submitted my Public Service Superannuation Act information about getting my public service pension. You had to be too disabled to do any job to get that. And a whole bunch of other stuff. And they finally gave it to me, and the guy said, well, we looked at the definition of the Reserve Force Pension Plan for Disability, and the fact that the public service definition is the same or similar, so we'll approve it. Now, before, you see, first when I applied for my pension, they said, well, which would you like, a deferred annuity, like when you get 65, or would you like a return of your contributions? To which I said, because I was getting medical release, where's the immediate annuity option? Oh, we can't do that for you. In order for you to get an immediate annuity, you have to apply for Canada Pension Plan Disability. Now, if you get approved, we'll give you your pension. And if you don't get approved, well, too bad, you don't get it. They didn't say it like that, but now here's the problem with that. One of the problems. The first thing is they're subsidizing themselves by abusing the Canada Pension Plan system. Instead of adjudicating their own files, they are submitting it to somebody else who is not part of the military, and then they're accepting that decision in order to decide if they're going to give me my fucking property back. That's a big deal. Now, the other problem has to do with the bridging bullshit. Okay? They put into the Reserve Force Pension Plan, you get 1.5% as a pension of your gross salary, whatever you made when you were serving. But they put a bridging part in there for 0.5%, so you would get 2% of your total, if you count the pension plus bridging. Now, the way they have it set up is that you can never get bridging if you're a reservist. Let me explain. You apply like they told you, you get denied. You don't get your Canada pension plan, you don't get your reserve force pension plan, and you don't get the pension bridging onto the reserve force pension plan. Let's say you apply for the Canada pension plan, you get approved. Now, you will get your reserve force pension plan, but they will say you're getting the Canada pension plan disability, so you don't get a bridging payment. So they've basically put a carrot on paper in front of the veteran, something that they cannot get. Now, I submit that that's cruel and unusual punishment, especially for someone who's been injured in service. What they ought to do, I think I will call it quits. I'm feeling a bit, I've had a sore throat and sinus infection last 6 months. What they ought to do is they ought to change the Public Service and the RCMP Superannuation Acts to reflect a definition of disability that is the same as the Canadian Forces definition of disability. Now, they also have to change the Reserve Force Pension Plan regulations. According to Section 2 of the Canadian Forces Superannuation Act, to be disabled, you had to be unable to do your own trade. That's a very fair definition. You can't do your own trade because of disability, you get a disabled pension. Now, you're in the public service. They say that you're able to do another job. You just can't do your own. You don't get your pension. That's crazy. Now, I don't know if they administer it that way, but on paper, that's the way it reads. So instead of saying that 3 of the federal pensions, the Public Service, RCMP, and the Reserve Force Pension Plan, they all have the 3A definition, which is the any occupation definition of disability. But the military's pension has a 3B definition, as in Queen Regulation and Orders 15.01. It should be the other way around. It's common sense that if you're too disabled to do your own job, you should get your pension. Now, can't help it the way my mind works, I'll mention one other thing. And it's the similarity between clawbacks and the before 1999 Service Income Support Insurance Plan. They used the wrong definition of disability. So, when I was talking to that guy from Sun Life, I said, listen, here's one of the problems I got. Let's say I had enough public service pension and the Canada pension plan that you would have 0 payment to me. You would be now violating the common law about insurance, because the Consolidated Bathurst Supreme Court of Canada case in 1978 said that the insurer or the underwriter cannot pocket the premiums without having risk of having to pay the insurance. So clawbacks either limit or eliminate the risk. So by having them in the policy, you are violating insurance principles. You can't do that. You can't put something into a contract that you want to make a deal. You want to make more money, but you do it against the policy, the common law, which is precedent. You can't do that. See? So, I mean, here's where I was going with it, why I was saying assisted before 1999. Because in the 2007 Treasury Board Secretariat Report on Total Compensation that covered a period between 1993 and 2003, it covered a 10-year period. So they talked about the increase in the premiums for the Service Income Support Insurance Plan because of the change in definition that was implemented in 1999. So the problem was, in 1969 to 1999, between those years, they used the 3A definition of disability under Queen's Regulation and Orders 15.01, which is you can't do any job, but they should have been using the 3B definition, which is your own trade, for the first 2 years, followed by the other definition if you can't do it on any job after 2 years. So the Treasury Board report said this resulted in Canadian Forces members paying for insurance they didn't get. Now, see, that's a big deal to me. In effect, the person who wrote that paraphrased the Consolidated Bathurst case. I just thought of that connection I just made. But the same thing can be said about clawbacks in general, because there were 793 zero-sum veterans for the Pension Act deduct clawback under the Manouche case, that, if I recall the number right. So those people paid premiums for nothing. You're not supposed to pay premiums for nothing. That's fraud. That's dishonest. If I'm going to get insurance coverage, I'm paying premiums for the peace of mind. I could go through my entire career, not become disabled. People might say, what a waste of money. No. According to the rules of law and common sense, you paid for peace of mind. You're supposed to think that if anything happens to me, I have insurance to cover me. But clawbacks eliminate that peace of mind. They don't even seem to understand how stupid clawbacks are. It increases the risk of them having to pay punitive damages, especially when you put the fact that they're lying about it right from the get-go, because that's a pretty serious thing. They need to look into why do they feel it's okay to not tell us the truth. When I was thinking about some of this stuff, not necessarily the stuff I'm talking about this time, the Customs Act, for example. In that act, they have a provision that says if you're questioned by a customs officer when you're crossing the border, you have to answer truthfully. Now, what a stupid fucking law. Anybody that's a normal person, passenger customs, going to answer truthfully. Now, the only ones that are going to answer dishonestly are crooks who are meant to try to steal or get away with something in the first place. So I think that they shouldn't have put that law on the books. However, it got me thinking. The government has a duty to be honest with us. So the fact that they're lying about the underwriter of these 4 federal government plans is a big fucking deal. I can imagine they're going to say, we didn't know it was that big a deal. Everybody does it. All of the insurance, all the employers across Canada does this. So because they do it, it's okay for us to do it too. Now on that note, I should shut up. When you think about those 2 cases that I was talking about, the Université de Laval, Federal Court of Appeal 2002, and the National Bank of Canada, Federal Court of Appeal 2003 cases, if you read between the lines, Canada Revenue Agency was calling them liars because they submitted false paperwork and they got took to court because of it. Now, I'm assuming, but I think it's safe to assume, that whatever forms were on file had to get changed. After the case, they said that Manulife made the payments, yeah, but they were really from the employer, so I can't see the paperwork not getting fixed. Now, it might surprise me, maybe they left it alone, but anything that's submitted for unofficial purposes, like taxes, ought to be straight, factual. Shouldn't be any wiggle room, no interpretation, no bullshit, okay? Because they're going to assess your taxes based on that. So if you start off by lying about your role in the insurance, you can forget about asking us to pay taxes, you son of a bitch. You want us to pay taxes on long-term disability insurance, you submit proper paperwork, honest, truthful, and no bullshit. Anyway, I'm going to call it quits on that note, and thanks for watching, and see you next week maybe.